Hi, my name's Rita Crompton, or Inventor Lady as I've been nicknamed around here. I spoke to you before about patents and the problem that you may encounter if you get a patent too soon. Today I want to talk to you briefly about the overall intellectual property strategy that you may want to consider. And the first thing that you need to really understand is the difference between your design patent and your utility patent. The utility patent is certainly more valuable if you can go that way, and talking to your patent attorney, you'll be able to really understand the specifics that go into deciding which one of those is most appropriate for you. One of the other pieces that we have to deal with is whether or not you should get a provisional patent application. And this is more of a strategic move than anything else. If you just need to be able to say patent pending, so it's important to get some words down on paper and submit them to the USPTO, or if it's more of a budgeting issue and you can get someone that will do the front end part as your provisional patent application and then the back end part is your claims, it gives you now a year or so to be able to budget out the cost of getting that patent filed. So those are some important pieces to consider. If you can't get a patent because of prior art, then your trademark becomes incredibly valuable and can often be actually more valuable than the patent. So pay a lot of attention to the name. Sometimes you may license your patent and your trademark as well. If you can't patent something, you can grab a lot of market share based on a very good trademark. The other part of the strategy is that during that time period when you're saying patent pending, sometimes you have about a year and a half, 18 months or so, all the way up to 5 years if you're doing software, and sometimes even longer. You can get a lot of market share with a good trademark and patent pending status. A lot of products have an average lifespan of 7 years. So before you even know whether or not you're going to be granted a patent, all right, you can have a lot of sales and have a lot of market share. So it's real important to understand all of those pieces. Another important part of your intellectual property is your domain, and I think this is one that most people forget. It's important to be able to have a web designer and a marketing person working together so that you have got a very valuable tool when it comes to marketing your product. I run into people a lot of times who have had beautiful webs designed for them and paid thousands of dollars for these websites, but they never really get picked up by the search engines. And this is a problem. Having a beautiful website on page 55 of a Google search doesn't do you a lot of good. So it's important to really understand the marketing dynamic that's involved in that website. So get people who can help you. Slapping up a website is not in your best interest. One, it makes you look weak, unprofessional, paying a lot of money for it. Sometimes it puts you on page 50 or 55 of a Google search. There's a balance in there that you're looking for. Get some help. Understand what all of the elements are that need to go into your marketing plans from the early stages that an inventor is looking at. If you need any help, you have any questions, please contact us through the Inventors Roundtable website, www.inventorsroundtable.com.